Welcome to the No State Project. I'm your host, Marc Stevens, author, of course, of Adventures in Legal Land, and, of course, the released finally after all these years. Yes, unfortunately, it was years. Government indicted. I'm glad to be with you here on it's November 23rd edition of the No State Project here on LRN.FM. And if you want to join me on today's show, it is 218-632-9399, 218-632-9399. And I have started shipping the government indicted. A lot of overseas orders, which is, hey, fantastic. But I have to do this stupid little customs thing. I've got one of them over here, but I got to do that customs thing, so I actually have to have the post office open when I do it. So, not so good news on the overseas stuff, but I promise that I know I have the glasses on because Monday morning I'm having surgery, but we're going to have the overseas stuff shipped on Monday. And again, I apologize for the delay, but it just was one of those things. I just could not get to the post office. It was kind of one of those odd things. It rained, record rain here in Phoenix in the Valley of the Sun the last couple of days, especially yesterday. And what didn't happen, I didn't get the books until very late on Thursday, so I couldn't ship anything on Thursday. But a lot went out yesterday. Again, I appreciate the orders, appreciate the support. Not going to be able to, again, the overseas ones, not until Monday. But after the show, I can continue sending the domestic ones. And that's, part of the problem being that, the domestic ones, I don't have to wait for they don't have to be open. They've got that nice computer there. So we've got that. But we've got a lot of stuff to get to today here on the No State Project. Again, my name is, the website is markstevens.net. And if you want to join me, it's 218-632-9399, 218-632-9399. And as usual, I had just a big week. Always had a lot of stuff going on during the week. It's been a lot of tax stuff, a lot of stuff with the Canadian Revenue Agency. So if I say CRA, you're not familiar with that, it's the Canadian Revenue Agency. These are the group of psychopaths that are the equivalent, the Canadian counterpart of the Internal Revenue Service. And I get this where there's a big, kind of like an urban legend that is perpetuated on the internet, of course, that for some reason people believe that Canadians, just as a group, are more friendly. That it's not true, at least when it comes to as far as bureaucrats as a whole, because it's been my experience. And maybe it's because I'm calling from Phoenix, Arizona, and they're looking down on me as some kind of, bloody American. I don't know. But the Canadians seem to be just as angry, just as dishonest. And this is one where I had it was near Edmonton, I think it was in Red Deer, where there's a writ of seizure. And I may have mentioned this on the show before. And they spoke to me as, "Oh, Mark, you don't understand Canadian law. You need to go get a Canadian lawyer. No one's trying to take your client's property. That's silly. We're not trying to do that." And you're like, it's a writ of seizure. And I even had to say to them, if you're trying to gaslight me, it's a pretty bad, it's a pretty poor excuse for gaslighting, because I may be American, but I'm not buying that kind of garbage. The idea that that they're not seizing the property is just laughable. But I'll talk more about. We had a lot of stuff that I did in Toronto this week, and so I actually spoke to a supervisor above and two supervisors above, Jivraj, who got very hostile with me a few weeks ago, and he yelled at me. When I asked him, "Well, why are you getting so hostile?" He says, "Because you keep asking me the same question." And you just have to answer it the first time. You see, rational, normal people engaging in a conversation, adults, when you ask a question, when someone asks you a question, you generally answer it. And if you don't answer it, if it's a really important question, they'll ask it again. So we'll get to that. I want to get to your calls. It looks like we have and when you do call here on the show, unless you've called before, we don't screen the calls. I don't have the ability to do that. Wouldn't want to really do that. So when I bring you up on the air, it is always by your area code. So we have area code 541. What's your name? Where are you calling from?
Hey, Mark.
Yes, what's your name? Where are you calling from?
Hey, my name is Martin. I'm calling from Oregon.
Martin in Oregon. What do you have for us today?
Well, I was arrested out of my vehicle for not giving my name to the police officer after ostensibly running a red light. And basically, I was trying to explain to the officer that I didn't think I needed to give him my driver's license because of the whole right to travel thing.
Did you say that?
I did say that, which is obviously not the best time to be arguing that with a cop.
No. What was his response to that?
I had told him, it might have been just uncanny timing, but I told him, hey, I'll write my name down on a piece of paper for you. And at that moment, I was pulled out of my car by 3 or 4 cops and arrested for interference with a police officer.
3 to 4 cops? Where were these 3 to 4 cops when this lead cop was asking you for your license?
They had slowly been surrounding my car. One of them was a supervisor, and yeah, it was straight Gestapo tactics. It's quite unsettling to have your local police department act in this way. I mean, yeah.
Well, by Gestapo, I mean, were there? Did they have batons out? Did you get beat up?
No, it's just that I was being quite peaceful and trying to be respectful. I told the arresting officer before they pulled me out that I'd been studying law a bit recently and that I just wanted to fully understand. And I, basically told them that I had my driver's license in the vehicle. It just wasn't within reach, and that I also had a passport in the car. And so I was just basically, I took too long, and like middle schoolers, they right before they pulled me out, right when I said, hey, I'll write my name down on a piece of paper, the supervisor said, well, we asked you 3 times, and they yanked me out, in a violent way, but they didn't beat me up or anything, but they definitely didn't let me, turn around and do all that. They definitely put me against the car and did it all for me.
Yeah, the side of the street is not it's not really the best opportunity to try to talk rationally with a 5-year-old with a gun. That's just it's just common sense. I guess the limit in Oregon before they get violent or more violent is 3 times. So 3 times and we drag you out of the car. Well, I'm glad you weren't hurt. I mean, now at this point did they search the vehicle?
As soon as they pulled me out of the car, they said they smelled dope. And, yeah, they ended up searching the front of my vehicle, just the passenger area, my driver's area, but they didn't go through the back seats or the trunk. And they left my car there, and I told them just to leave it unlocked, and they left it there.
Did they find any dope?
No, they didn't. Basically, my sweatshirt was really stinky at the time, and so it was a no-brainer. It stank.
So I guess the only dope's there with the 3 or 4 cops that pulled you out of the car.
What'd you say?
I said the only dope that was at the scene with the 3 or 4 that pulled you out of the car.
Yeah.
Okay, did you spend the night in jail?
Yeah, I was in jail it might have happened on like a Thursday or a Friday, so I was in jail for 3 days. They charged me with DUI, reckless driving, because I have a few reckless on my history, and they tagged that on. And then...
well, let me ask you a question. Martin, do you hear the bumper music? Apparently he's not here. Well, we're up against a break. You're listening to the No State Project here on LRN.FM. It's November 23rd, 2013. We'll be back here with your calls at 218-632-9399, 218-632-9399 in just a moment. Don't go away. Welcome back to the No State Project. We're here live from the Fortified Compound in Phoenix, Arizona. It is November 23rd, 2013. And you can call into the show at 218-632-9399. That's 218-632-9399. We can also Skype during the show, of course. My username is FrankRizzo3, and then I can put you into the No Stay Project chat. And, of course, the reason why I do that is because I can't respond to 15, 20, or 30. Yeah, we've actually got that many listeners now, Cal. So I can't respond to everybody all at once, but it's easier just to get into the chat. And plus, if you need to do some role-playing, like it looks like Martin's going to have to do, and to be able to prepare to go to court if you have to do that, or if you're going to be dealing with bureaucrats in any fashion that are attacking you, then we get you into the No State Project Skype chat, and then you can just set up another room and do some role-playing. Most of us that are in there have already been through, been in a den of thieves, and so we've got the experience and are able to help and get people prepped for court. Again, the number is 218-632-9399. And if you disagree with anything on the show or on the video, because, yes, we're going to have some video the first hour posted just like the last few weeks, 218-632-9399. Join me live on the show and present your evidence or show where something that I or someone else presented that was inaccurate. I want to get back. We've got Martin in Oregon who spent 3 days in an Oregon jail. Sorry to hear that. So, did you have to bail out, or was this a situation where it was OR?
It was OR. Got pretty busy.
Okay, and what kind of conditions? I mean, did you have to do an arraignment right there and then, or did they just release you and give you an arraignment date?
My arraignment was a few days out when they let me out, and then they ended up scheduling my arraignment for about 2 weeks later, which is this Monday.
This Monday. Wow. Well, we not a lot of time to prep. Monday. Okay, we've got Monday. Well, have you...
Basically, I don't want to plea, so I'm filing a demurrer and a motion to dismiss. Basically, yeah, I'm actually not too sure about anything right now.
Okay. Have you seen the video that I did on YouTube? It's on markstevens.net about the unsigned plea of guilty.
No.
Okay, we got to screen it. We've got to start screening the calls here. I'm kidding. Take a look at the video, but I'll walk you through that just a bit. You're intending on pleading guilty because you're trying to stop the process. Because anyone who's ever been in there, if you go in there with a demurrer, you're just trying to get some answers. So, hey, where's the evidence of any kind of jurisdiction? Where's the valid cause of action? And, hey, where is there an honest antagonistic assertion of rights by an injured party? An adversary, since it's an adversarial proceeding. When you do that, they just want to rush you out of there, and they will accuse you or they will lie. I know, it's a shock. I know. Judges, lawyers, they lie, and they lie all the time. So they'll lie and say that you're refusing to plea. They may deny the motion without any explanation whatsoever because they can't explain because there's no evidence. And so when you have the unsigned plea of guilty, you've got documentary evidence that you can then have in a file to change the judge later and get the plea of not guilty stricken. So I go through this in a lot of detail in there. You're not supposed to sign it. It's just a matter of stopping the process so they don't just set it for a pretrial and get you closer to a trial and a conviction. Okay? So it's your intention, and then you're asking what evidence has the prosecution given to prove the Constitution and laws of the plaintiff state apply to me, and there's any jurisdiction over me at all.
Well, I was thinking of, I was planning on handing in this demurrer on Friday yesterday, but I didn't, and I'm thinking if I brought it with me to the arraignment, could handing it in on Monday say, hey, I have this, therefore we need to schedule like a pretrial hearing or something? No.
Pretrial hearing is only appropriate after an arraignment. You can have a hearing on the motion, have a heard right then and there. Now, if they were going to play hardball with you, well, the prosecution has to see this and have an blah blah, and the prosecution should have an opportunity to respond to it. I don't think he needs more than a few minutes. Just read it and present the evidence that you're supposed to already have. It's like an open book test. The evidence should be there already, it shouldn't have been filed against you. But if they want to give you a hard time that way, I would just say, well, look, you know what? I'm not interested in coming back here. I'm not interested in having a trial. I intend on pleading guilty, and then you launch, and you don't give them a chance to answer. Just ask the question: has the prosecution given you evidence to prove the Constitution laws apply and that there's any jurisdiction over me at all. Now, the prosecutor has to do that anyway. I know somebody was on the chat here, and they basically put a book in here of citations, and all right, we've already gone through so many here, but it's basically stating the obvious. The burden of proof of jurisdiction lies on the asserter, the one who files the complaint. So when you do this, Martin, you're only asking that the prosecution provide the evidence they have to do anyway. Now, they'll try to gaslight you. I'm not going to have this so-and-so make a mockery of this proceeding, which we've had them say before. And even a lot of times the judge, well, just relax. He's just asking for evidence. You're required to have this anyway. So that's the way I would do it if they're not going to hear the demur right away. I intend to plead guilty. Just know that when you're starting to ask for evidence the prosecution's supposed to have, they tend to get a little upset.
Well, so what's the difference between intending to plead? I mean, I'll watch the video. I understand, but I'm under the impression that if I plead anything, it's not good for me. And I was trying to basically handle it administratively by just buying myself some more time to file more motions and kind of. I just don't understand what the intending to plead. How would I intend to plead and not sign it?
Okay, this is because if you read it and there's a copy available on the website, you can get the template. If there's a problem, you can just email me. I'll send you a copy. It says in there that any plea, and they'll even tell you if you ask them, if you look in the rules for Oregon, no plea may be entered unless it's voluntary and intelligent. So there's certain things they have to tell you. There's a whole interview process that they have to go through whenever they accept a plea of guilty anyway. They probably do that before they run everyone through the system. We just want everyone to know if you plead guilty, you're waiving your right to a trial and all this other stuff. So they're going to have to tell you a lot of stuff anyway. The reason why you're intending, I could say right now, I intend on delivering a tremendous show for this network today. It's going to be the best show this network has ever had. And then the train wreck of my show continues. Your intention is different than what the actual final product is going to be. The intention is just to let them know what you want to do. It's conditional, though. You're not to enter a plea. So I'll do my own little civil disobedience here. I would advise you not to enter a plea unless they can produce some kind of evidence, which they're not going to be able to do. The unsigned plea of guilty stays unsigned. Okay? We'll finish up on the other side. My name is Mark Stevens. That's I love this bumper. I know the callers can hear the bumpers now, so it's Lead Boots by Jeff Beck. I kind of biased. I always clip out the best parts of that. But we'll be back here on LRN.FM with the No State Project. I'm your host, Mark Stevens. This is the November 23rd edition of the No State Project, and we'll be back with your calls in just a few moments, so don't go away. Yes, welcome back to the No State Project, coming to you live from the Fortified Compound in Phoenix, Arizona. Glad to be with you back live on LRN.FM. That's Liberty Radio Network. LRN.FM, November 23rd, 2013. I know yesterday was the 50th anniversary of the conspiracy to kill John F. Kennedy. I have something I want to play that later. Someone just did an outstanding job to have such an effective video in only 4 minutes. It's a credit. I'll bring that up later, though. You want to join me here on the show? It is, what is the number here? I should know this by now, right? It is 218-632-9399, 218-632-9399. Want to welcome back. We've talking with Martin in Oregon. We're discussing the entering of a plea or not entering a plea. So, Martin, welcome back. Do you understand a bit better that's just a tactic to be able to bring out that that the prosecutor has no evidence and the judge is actually colluding with the prosecutor to your detriment?
Yeah, I was just wary of, the judge entering a plea for me or something, so I guess this is a better way to go about it, to do it myself, but not really be doing it in effect.
Well, yes, you're not doing it, and so what you're doing when we have it in writing, I know this isn't it, but we have just to demonstrate, when we have it in writing and it says plea of guilty, the judge is going to have a pretty hard time trying to say that you were trying to plead, that you were refusing to plea. And that's why we do it. And so everybody, and you can even say, "Excuse me, sir, are you under the false impression I'm refusing to plea? I'm not." And so what I go through in the video is that, you'll have the evidence, the documentary proof, plus if there's anybody witnessing or if you can get a transcript of it, that the judge is colluding with the prosecutor. He knows the prosecutor doesn't have any evidence, and he lies to cover that up by saying that you're refusing to plea or they couldn't ascertain your identity. They couldn't ascertain your plea. And that's why we do it in writing, to make it more difficult for him to try to get away with that. And it's easier for you and me to then file a complaint against the judge that he's a psychopath, that he's a liar, and he's actually colluding with the prosecutor. And if anyone thinks that when the judge does that, and we've had many people call in about that this has happened. I've had it happen to me. If you don't believe that when you go into court and you're asking for evidence that the prosecutor has to prove the constitutional laws apply to you and that there's jurisdiction, and the judge then says you're refusing to plea and I'm going to plead not guilty for you, if you don't think that that's collusion between the judge and the prosecutor or the police officer, I call me. Explain how that's not evidence of collusion. Explain to me why the judge would be doing that. But anyway, I want to get back to Martin. Martin, if you have any questions or anything else that we can help you with here to maybe you can get this tossed out on Monday.
Sure. Yeah, I just had an interesting note. Basically, why I wasn't giving him my name was basically because I didn't want to enter into a contract. And so, I was being pretty stupid. I probably just should have just given him my name or whatever, since it really doesn't matter, I guess. I was just kind of feeling it out, and I didn't think they were going to arrest me.
Okay. Well, Martin, let me ask you this. What led you to believe, what facts were presented at that stop that led you to believe that this police officer was trying to contract with you?
Well, basically my assumption was just that I wasn't driving. I told him I wasn't driving, that I was traveling, and that I didn't need to have proof of a license, even though I had.
You have one. Well, let me ask you this. When those lights went on, did you think that you had a choice on whether you could stop, or did you believe that if you did not stop when he put those lights on, that he was going to stop you by force?
Yeah, that's why I pulled over.
So
I've gotten in trouble in the past for not pulling over.
Okay, so you know that when he throws those lights on, and when you're having your first interaction with this individual, you know it's not voluntary. That he will go through a force continuum to get you to stop, to comply with his with his demands.
Yeah, I honestly wasn't thinking with the end game in mind. I was just trying to feel out. I don't know. I was just kind of. I had a little bit of information, and there's nothing more dangerous than a little bit of information.
That's what they keep telling me. So, can we at this particular point? There is overwhelming evidence that this man is not trying to contract with you. So, for you and those listening, if you're in a similar situation or you find yourself in a similar situation, this individual is willing to kill you dead. That's not hyperbole. I'm not exaggerating, okay? At the very least, he's willing to do serious bodily harm to you to get you to stop and to comply with his orders. They will run to the window of the car with a gun pointed directly at your head, screaming at you if they have to stop you by force or if they have to, go through any kind of chase, which I'm not obviously recommending. So for those who, again, let's not take. I think the word you used was assumption. That's just as bad as having just enough enough information to get yourself in trouble. So for the next time, we know they're not trying to contract with you. And anyone who tells you that they're trying to contract with you, just walk them through the same scenario that I just did with you. Well, let's take this one step at a time. Okay, people.
Sure.
And as a general rule, people who are willing to kill you to get to get compliance are generally are psychopaths, and they're not looking to trick you. He's not going to sit there and say, "When I write you up, I'm going to put your name in all caps, And if you sign this, you're going to have a contract. Again, I don't want to spend any time right now on it. Maybe we can get into that later. But for Monday,
Here's the deal. When I was in handcuffs in the back of the car, supposedly out of earshot, I heard the supervisor tell the arresting officer, "Yeah, he didn't want to enter into a contract with you." And I hadn't even brought up the word contract at all, and I heard the supervisor tell the arresting officer that. And then in between the supervisor slamming the back door on me a few times when I was asking questions, I asked that about the contract to try to clear up the misunderstanding. I was like, yeah, I was trying to, retain my rights to not enter a contract or whatever. And he looked at me like I had three heads, and he said, "I've never said the word contract. What are you talking about, contract?" But I clearly heard him say it.
Yeah. Well, the supervisor may have just been, stating the obvious or being sarcastic. I think you could see if you have to, if you feel the need, which I really wouldn't do, and maybe just asking the one time, if you have to start talking to these people, because they're going to use it all against you anyway. If anything, just ask them for evidence. Do you have any evidence that, that your laws apply to me and if there's any jurisdiction over me whatsoever? So at least later you can use something like that against you. You can show that's bad faith. I mean, the guy knew at the stop that he had no evidence in jurisdiction. It's not like this Rosga guy up in Minnesota with our friend John, who didn't know until after the fact because he had just made the assumption. Now he's got it. Now you got it right there at the stop. But as far as Monday, what I would suggest is, I have a motion template. I don't know if you mentioned that you had that. For me, it's based on lack of evidence the Constitution laws apply. There's no valid cause of action. There's no injury. There's no real adversary. And it also has a section that talks about that police authority does not expand or enlarge the jurisdiction of the courts, that the courts are limited to cases and controversies, and just because the cops may be given some kind of statutory authority to do X, Y, Z does not enlarge the jurisdiction of the court. I've even had a few judges admit that. Say, we don't even know why you would put this in here, sir. This is so obvious. Of course, police authority, the jurisdiction of the court is not based on the authority of the police officers. So we're up against the break, so if you have any more questions, we'll get them off air. My name is Mark Stevens. You want to join me here on the big show today? It's 218-632-9399, 218-632-9399. You can also Skype me during the show. It is Frank Rizzo 3. So we'll be back here with your calls and questions here on LRN.FM, here on the No State Project in just a moment. Don't go away. Yes, welcome back to the No State Project. I'm your host, Mark Stevens, author of Adventures in Legal Land, and, of course, the newly released Government Indicted. We're trying to rid the world of the worship of psychopaths, because people who call themselves government, because there really is no such thing as a government, there's just people. They are psychopaths. They have a callous disregard for others. They are pathological liars. They have massive egos, and they do not accept challenges very well. They don't tolerate challenges very well. And speaking of, I'm going to get to Armando in just a second, so I missed the video for the last segment, but I wanted to be able to say this because somebody who's done a lot of work helping people in court, doing the Skype chat, and going as a media rep is right here in Phoenix. He's gone with me a number of times. He's a big support. He's what we need to have. Even if he's not saying anything, the fact that you're not standing in court all by yourself is a big deal. And there was a big thing that happened this week. So I guess it's like the guts of war. I have not heard the audio of this. Apparently we have an audio to prove this. But our own Dan Gould stood up in a Phoenix Justice Court this week and called BS. Actually, BS. This is BS. I'm cleaning it up a little bit for the air. This is BS. Called a judge a liar to his or her face, and amazingly, from what's reported, didn't go to jail, which is quite something. And maybe we'll have someone there come on the air today and relate to us, an eyewitness to this. Maybe we've got some audio queued up. Maybe we can get that broadcast. But kudos, that you did good. You did good there, Dan. I do appreciate that. That took guts. And it needed to be said. And more of us need to be telling these people that if they, you are a liar. But we'll talk about that more hopefully later in the show. I want to bring up, he's been on the show before. He's been very patient so far today. Our friend Armando from Texas. Welcome back to the No State Project, my friend.
Hey, Mark. How's it going?
Doing well. It's actually, we had the record rain here in Phoenix this last day, but it's just partly cloudy today, and it's starting to dry out there. But I tell you, I know Dan may have, I think it was Dan or someone mentioned on the chat that it's getting the ground good and ready for a new season of poppy. So I'm hoping that this year, starting January, I'll actually get a pretty good crop.
Oh, sounds good. Yeah, we're expecting some rain here also, and some cold weather.
Well, you have some updates for us, though. I'm hoping that this is pretty good news.
Yeah, well, nothing major. The last time I called in, we were going to file that motion to dismiss for misconduct, and the fact that they had they had answered their request for admissions, that the contract or the agreement doesn't require the borrower to pay. There was a few requests that mentioned something like that, and I filed it. And I guess what happened is that they set the hearing too soon. So when I showed up for the hearing, the attorney had walked up to me because he hadn't had a chance to file anything. So they gave me the objection. I think I sent it to you, but the first part of the objection was referring to some rule on the Texas Rules of Procedure that had nothing to do with my motion. And then, of course, they also stated that they didn't have enough time, so that whole thing got rescheduled. I talked to the attorney about maybe seeing if we could reschedule the trial date, because I wasn't gonna be able to go to that trial date on the 19th. So he mentioned something about doing a DCC and no, it's over there. Doing a DCC so that we can get together and start picking our dates in advance, so that we can have these hearings or trials. And then he also mentioned to the judge that we could go to mediations. I don't know if I was supposed to object at that time, but I figured, you know what? Yeah, I guess I can talk to them about some mediation. Maybe I can find out some things about what evidence they have. And since then, they have all they did was they refiled all the evidence that they had filed before, and then a few more documents. And as I mentioned on that email, I think maybe this would be a good time to file some motions to strike their evidence. And I'm also going to file, I guess, a response to their objection. So those are my. I guess that's what I'm planning, and I haven't gotten a call. I gave the attorney my number. He was supposed to call me so we can start arranging some stuff, some hearings and stuff, but they haven't contacted me yet.
Well, what about, was anything heard on the misconduct?
No, that was the hearing we were supposed to have, but they didn't have. It was kind of scheduled, too soon, and that was one of his concerns, that they didn't have enough time to respond to the motion.
All right, so my first concern would be getting that one reset so that you can have the hearing on that. That would be I think you're right about the motion to strike. I think just as important, if not more important, is to get the issue of the attorney misconduct addressed, because we basically had an admission from them that they're making arguments outside the evidence because they said we don't have to. I mean, they put that right in the document. They admitted that they didn't have to have evidence.
Yeah, and that I guess the motion the response that I'm gonna do to the objection, I guess I'm gonna obviously I guess there's that rule, the 91. I don't remember exactly what it said, but of course I've stated on there that this motion to dismiss has nothing to do with that. It's just based on the answers that they've responded on their request for admissions, and I guess some other points. And then at that motion, I'll ask for a new date, make sure that the attorney has a new time, and make sure they contact me so we can set up the hearing on that motion. I guess that would be the thing to do with the response to the objection, right? Put on there the rescheduling of the hearing, and at an appropriate date, make sure they have enough time to respond. I don't know what they're going to respond with,
Right, well, so they've set the hearing date again. Do you have an actual date for that?
We didn't set a hearing date.
Okay. Well, that's good because what I would do is I would get a hearing set for these pretrial issues, the motion to vacate and the misconduct, and get them, bring them in there and to discuss those issues. And it's a good thing there's no trial date yet. I mean, I'm looking at this, and those who are not, who are just listening for the first time, we're dealing with this is a bank. This is a credit issue, and for it to get just to this point, this far in the process, it really works against them because they typically get a summary judgment against them in their favor. So, which is what they moved here, and that was, they were not given the summary judgment. So, I think any time, just in a broader sense of the people listening, anytime you're in a situation where a bank does not, or the IRS does not get a summary judgment, rubber stamped, you stand a pretty good chance of getting a fair shake, by the judge. To me, it's evidence you're not getting steamrolled like you usually do when it's the bank. So
yeah.
I would go for find out what day motion day is, maybe in a month to give you time to prepare, and maybe the first week of January, and have it on the motion, the motion to strike, and the motion for about misconduct and sanctions.
Yeah, we're gonna reschedule that hearing. I guess I'll put all that in the response to their objection, and then I guess I'll contact the attorneys, make sure that we set a date so that they have enough time to respond to the motion. But what I was thinking in terms of based on their response, the objection, I mean they don't address any of the issues that point out.
Right. I haven't had an opportunity to look at that, so I'll have to look at that during the week when I get a chance. I guess I'll be looking at it with one eye for a few days. I'm having that surgery Monday morning. I'm really looking forward to that. Well, hang on the line, Armando. We'll be back here on the No State Project and our friend Armando in Texas here on the No State Project in just a few moments. You're listening to LRN.FM, and the number here, if you want to join us, is 218-632-9399, 218-632-9399.